On the issue of marriage as a condition for reinstatement for Cadiz, where she must marry her boyfriend before she can work again with Brent, the hospital, school, owned by church. So they require that the complainant Cadiz working as the human resource officer who they claim to be obliged to be an epitome of good conduct or good behavior. They required her to marry her boyfriend before she can work again for Brent. So, what does the Supreme Court say about this issue? The doctrine of management prerogative gives an employer the right to regulate, according to his own discretion and judgment, all aspects of employment, including hiring, work assignments, working methods, the time, place, and manner of work, work supervision, transfer of employees, layoff of workers, and discipline, dismissal, and recall of employees. In this case, Brent imposed on Cadiz the condition that she subsequently contract marriage with her then boyfriend for her to be reinstated. So according to Brent, this is in consonance with the policy against encouraging illicit or common law relations that would subvert the sacrament of marriage. So here, a marriage as a condition of for reinstatement. The question here is this within the power of the employer, the right of the employer to have the management prerogative, no? Because in labor cases, normally it is a battle of management prerogative, the right of the employer, and the right of the employee to security of tenure. As far as I'm concerned, those two doctrines battle each other. So, statutory law is replete with legislation protecting labor and promoting equal opportunity in employment. No less than the 1987 Constitution mandates that the state shall afford full protection of labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. The Labor Code of the Philippines, meanwhile, provides Article 136 as written in this decision. Stipulation against marriage. It shall be unlawful for an employer to require as a condition of employment or continuation of employment that a woman employee shall not get married, or to stipulate expressly or tacitly that upon getting married, a woman employee shall be deemed resigned or separated, or to actually dismiss, discharge, discriminate, or otherwise prejudice a woman employee merely by reason of her marriage. So here, baliktad, no? Article 136, the woman is prohibited from getting married. The case of Cadiz, she is forced to marry her boyfriend, although they got married later on. So, with particular regard to women, RA Republic Act 9710, or the Magna Carta of Women, protects women against discrimination in all matters relating to marriage and family relations, including the right to choose freely a spouse and the right to enter into marriage only with their free and full consent. So this is the right of Cadiz, no? Magna Carta of Women. So weighed against these safeguards, it becomes apparent that Brent's condition is coercive, oppressive, and discriminatory. There is no rhyme or reason for it. It forces Cadiz to marry for economic reasons and deprives her of the freedom to choose her status, which is a privilege that inheres in her as an intangible and inalienable right. When a marriage or no marriage qualification may be justified as a bona fide occupational disqualification, Brent has the obligation to prove two things. Brent must prove two factors necessitating its imposition. First, employment qualification, okay, that you must marry your boyfriend, or you must not get married outside of wedlock, is reasonably related to the essential operation of the job involved. Second, that there is factual basis for believing that all or substantially all persons meeting the qualification would be unable to properly perform the duties of the job. So this is a difficult burden as far as Brent, the employer, is concerned. Brent has not shown the presence of neither of these factors. Perforce, the court cannot uphold the validity of said condition. If they were able to prove those two factors, the result of this case would be different. So, there are more important parts of this decision. So, let's tackle that in the next video.